I am not a confrontational man. I want to say that clearly, because what I did on April 17th, 2024 might suggest otherwise. A skid steer in my backyard at 7 a.m., a flatbed loaded by 10, a stage that had existed on my property for 9 days, gone before noon. That's not confrontation, that's assessment. I spent 30 years as a structural engineer. When you find an unauthorized structure on a site, you don't negotiate with it. You document it, determine the correct course of action, and act with the precision the situation requires. Sometimes that means a phone call and a repair. Sometimes it means removal. My wife Margaret designed the stone terrace in the summer of 2009. She sourced the Tennessee flagstone herself, sketched the layout on graph paper at the kitchen table, revised it 4 times, and presented the final design to me on a Saturday morning in September, with the quiet pride she brought to everything she made. We set every stone together over 3 consecutive weekends in October, Margaret on her knees with a rubber mallet and a level, me mixing compound and cutting stone, our 12-year-old daughter handing us tools and offering opinions with the confidence of someone who hadn't yet learned that opinions require expertise. Margaret died in January 2022. I maintained the terrace the way I maintained everything on the property, with the attention of someone who understands that maintenance is not separate from honoring. I knew every stone. Brenda Colton had been chair of the Magnolia Ridge Events Committee since 2017. She had wanted my rear lawn for the community gala since at least 2022. I told her no at the April 2023 HOA meeting. I told her no again in writing in September 2023. 1 paragraph, my personal letterhead, mailed to the committee's address. I considered the matter settled. I flew to Portland on April 4th to visit my daughter and grandchildren. 12 days. I turned onto my street on April 16th at 1:15 p.m. and saw something wooden through the gap in my fence line. Elevated. A platform edge with a decorative railing. A 40-foot stage. Concrete footings at all 4 corners. Fresh pour, pale gray, new construction. String lights screwed directly into the bark of all 4 oak trees. White bunting stapled to the rear fence. And at the terrace edge, 6 anchor bolt holes drilled into Margaret's flagstone. 3 stones cracked. The large piece at the north edge, the one with the diagonal red vein she had positioned there because she liked the way it caught the afternoon light, fractured along its full width. The quarry she'd sourced it from had closed in 2016. I sat in my car for 3 minutes. I was not deciding whether to act. I was determining the correct sequence. I called my demolition contractor. He was there at 7 a.m. The stage was on a flatbed by 10. I had 247 photographs, a 4-page site assessment, and every anchor bolt in a labeled evidence bag before I called my attorney. Brenda came to my door at 11:15. She said the equipment belonged to the HOA, and I had no right to remove it. I told her I looked forward to seeing that argument in court. I closed the door. 18 months later, a criminal trespass conviction, a $314,600 personal civil judgment, a $4,000 fine, and 18 months of probation. The terrace is still there. I am not a confrontational man, but I know what concrete footings mean. Footings are not temporary. Footings are what you pour when you intend something to stay. She had the wrong idea about what was staying. Before we jump into today's story, let me know where you're watching from, and be sure to smash that like button and subscribe for more content like this. I want to say that clearly at the beginning, because the events of April 2024 might suggest otherwise. They might suggest a man who reacts explosively, who escalates, who chooses force when conversation would have served. I want to explain why that reading is wrong, not because it matters for my reputation, but because the distinction between reaction and response is one I've spent 30 years understanding professionally, and it applies here as directly as it applies to any structural failure I've ever analyzed. Structural engineers don't panic when they identify a problem. They assess, document, and act with the precision the situation requires. Sometimes the situation requires a phone call and a repair. Sometimes it requires removing the structure entirely before it falls on someone. The stage in my backyard required removal. That's not a reaction, that's an assessment. I spent 30 years as a structural engineer, 22 of them with a firm in Atlanta, 8 of them as an independent consultant specializing in residential and light commercial construction review. I retired in June 2021. The plan had been that Margaret and I would spend the retirement years the way we'd spent the best parts of our working years, working on the property, traveling when we felt like it, having our daughter and her family visit in the summers. Margaret was diagnosed in August 2020. She died in January 2022, 18 months after the diagnosis, in the bedroom of the house we'd bought in 2001, when Magnolia Ridge was still a new development, and the lot at the end of Ridgecrest Court was the one nobody else had chosen because it was the farthest from the entrance, and the street was a cul-de-sac, and some buyers found that isolating. We found it perfect. 3.2 acres at the end of a quiet street. The rear lawn running 200 feet from the house to the back fence line, flat and open, with the particular quality of Cherokee County clay soil that grows grass thick and dark in the summer. 4 white oak trees she'd planted as saplings in 2003, spaced in a loose arc across the back third of the lawn, and the stone terrace. Margaret had designed the terrace in the summer of 2009. She'd sourced the flagstone herself, a Tennessee quarry she'd found through a landscaping magazine, a warm gray stone with natural red veining that she said looked like it had always been there. She'd sketched the layout on graph paper at the kitchen table, revised it 4 times over 2 weeks, and presented the final design to me on a Saturday morning in September, with the same quiet pride she brought to everything she made. We set the stones ourselves over 3 consecutive weekends in October. Margaret on her knees, with a rubber mallet and a level, me mixing the setting compound and cutting stones with a diamond blade saw I'd borrowed from a colleague. Our daughter Caitlin, 12 years old that fall, handing us tools and opining on the layout with the confidence of a child who has not yet learned that opinions require expertise. Margaret called it her proudest, non-professional accomplishment. She'd been an accountant for 26 years. She was good with numbers, precise about money, organized in the way that people who grew up without much tend to be organized. Nothing wasted, everything in its place. The terrace was different from what she did professionally. She'd made it with her hands. That distinction mattered to her. After she died, I maintained it. I maintained the entire property, the lawn, the oak trees, the fence line, the garden beds along the south wall, with the particular attention of someone who understands that maintenance is not separate from honoring. The terrace got the same care it had gotten when Margaret was alive. Spring cleaning, annual resealing, replacement of the sand in the joints whenever winter freezing worked it loose. I know every stone. Brenda Colton had been chair of the Magnolia Ridge Events Committee since 2017. I say this without animus, because what I'm about to describe is not personal in the sense that Brenda bore me any specific ill will. What she bore was the particular certainty of someone who has organized community events for 7 years and has begun to believe that community benefit is a sufficient authorization for anything she decides it requires. She'd wanted my rear lawn for the community gala since at least 2022. I'd heard it through neighbors before she ever asked me directly, the way things circulate in a 147-home HOA where the events committee chair is known for her enthusiasm and her persistence. The Aldridge property, the lawn, the terrace, perfect for an outdoor event, the kind of setting you'd pay a venue for. She asked me at the April 2023 annual HOA meeting. It was a direct, friendly request, Brenda at her most persuasive, the social organizer in full function, making a case for community benefit and shared space. The gala raised money for the Community Improvement Fund. The venue choices were limited. My property was exceptional. I told her no, not rudely, not extensively. I said the property was private. I preferred to keep it that way, and I wished the committee well in finding another venue. She thanked me and moved on. In September 2023, a formal written request arrived from the events committee. A 2-page letter on Magnolia Ridge Community Association letterhead describing the proposed 2024 Community Gala, the anticipated attendance of approximately 200 residents, the committee's vision for the event, and a request for permission to use my rear lawn and terrace as the venue. I read it carefully. Then I wrote a 1-paragraph response on my personal letterhead, dated September 14, 2023, and mailed it to the events committee address. Dear Ms. Colton and the events committee, I appreciate the committee's detailed proposal and the clear effort that went into it. I decline the request. The property is not available for community events. I wish the committee well with the 2024 gala planning and hope you find a venue that suits the event's needs. Regards, Thomas Aldridge. 2 refusals, 1 verbal, 1 written. I considered the matter settled. My daughter Caitlin had been asking me to visit Portland since the previous summer. She'd moved there in 2019 with her husband and their 2 children, my grandchildren, 7 and 4. I'd been out twice since Margaret died, both times brief, both times with the particular distraction of a man who has difficulty being away from the property for extended periods, because the property is where his wife still lives, in the sense that matters. Caitlin had been patient about it. In March 2024, she'd called and asked directly. 2 weeks, April. The children had spring break. She wanted me there for the full visit. I said yes. I left on Thursday, April 4th. Drove to Atlanta, flew to Portland, arrived at Caitlin's house by early evening. 2 weeks of grandchildren and Pacific Northwest spring, and the particular restorative quality of being with family who know you well enough to not require you to explain yourself. I flew back to Atlanta on Tuesday, April 16th, landed at 11:40 a.m., drove north on 575 through the familiar Cherokee County landscape, the terrain I've lived in for 23 years, the exits I know by landmark rather than number, the turn onto Magnolia Ridge Boulevard that brings you through the development entrance and toward Ridgecrest Court. I turned onto Ridgecrest Court at approximately 1:15 p.m. The cul-de-sac is 400 feet long. My house is at the end of it. From the turn onto the street, the left side of my rear lawn is partially visible between the gap in the fence line and the neighboring property. A narrow sight line that normally shows nothing more than grass and the lower trunk of the southernmost oak tree. Something was different. I slowed the car. The sight line showed something wooden, elevated, a platform edge with a decorative railing. I drove to the end of the cul-de-sac and stopped the car in front of my house. From the driveway, looking through the side yard gate toward the rear of the property, the full picture was visible. A 40-foot by 24-foot elevated stage platform, 6 inches off the ground, constructed from pressure-treated lumber in a standard event stage configuration. Decorative railings on 3 sides, white painted, the kind used for outdoor wedding venues. String lights woven through the branches of all 4 oak trees, attached with hardware screws visible from the driveway. White bunting along the rear fence line, attached with staple fasteners. And at each of the 4 stage corners, concrete footings, 4-inch diameter, recently poured. The concrete still the pale new pour gray that I recognized from 30 years of reviewing construction sites. I sat in my car at the end of the cul-de-sac. I am not a confrontational man, but I am a structural engineer, and I know what concrete footings mean. Footings are not temporary. Footings are what you pour when you intend something to stay. Someone had poured footings into my lawn, into Margaret's lawn, the lawn that Margaret had shaped and seeded and tended for 20 years. I sat in the car for 3 minutes. I was not deciding whether to act. I was deciding the correct sequence of action. The same process I've applied to structural problems for 30 years. What needs to happen first? What documentation is required? Who do I call? I picked up my phone. Marcus Webb and I had worked together on and off for 20 years. He'd done demo work on 3 projects where I was the structural engineer of record, and we'd maintained contact after I retired. He ran a mid-sized demolition and excavation company out of Canton. He was reliable, precise, and had the quality I valued most in contractors. He did what he said he'd do, when he said he'd do it, without requiring management. He answered on the second ring. "Thomas, thought you were in Portland. Just got back. Marcus, I need a machine at my address tomorrow morning. Full removal job. Residence scale. What are we taking down? Someone built a stage in my backyard." A pause. The pause of a man who has heard unusual things in his professional life and is deciding whether this qualifies. "I'll be there at 7. I ended the call. Then I got out of the car, went into the house through the front door, set down my bags, and went directly to the rear door to look at the stage from the backyard. The terrace was visible to the right of the stage, or what I could see of it. The stage had been positioned to the left of the terrace, using the terrace as an adjacent surface, the way an event planner would use a natural stone surface as a complementary feature. I walked to the terrace, 6 anchor bolt holes, drilled into the flagstone surface at the terrace edge. The staging cables had been anchored to the terrace to stabilize the stage frame. 3 of the holes were in a flagstone that I recognized immediately. A large piece with a distinctive red vein running diagonally across its face. A stone Margaret had specifically selected and positioned at the terrace's north edge because she liked the way the vein caught the late afternoon light. The drilling had fractured the stone along a natural fault line that ran parallel to the vein. The stone was cracked. It could not be repaired. The crack ran the full width of the piece. I stood at the terrace for a long time. She had set that stone on a Saturday morning in October 2009. I had mixed the compound, and she had positioned the stone twice before she was satisfied with the placement. I remembered the sound of her rubber mallet tapping it level. I remembered her stepping back and looking at it with the expression she had when something was right. I went inside and got my camera. I spent the next 2 hours photographing every element of the construction. The stage platform, the footings, the hardware in the oak trees, the bunting attachments on the fence, and every anchor bolt hole in the terrace, with particular attention to the cracked flagstone. I photographed from 6 angles, with a measuring tape and frame for scale, the way I'd been documenting construction conditions for 30 years. Then I sat at the kitchen table and called Claire Sung. But before I called Claire, I called Caitlin. "Dad, you land okay?" "I landed fine." I paused. "Caitlin, someone built a stage in your mother's backyard while I was gone." A silence. "What?" "Brenda Colton, the events committee. They built a 40-foot stage on the rear lawn, with concrete footings." Another pause. "They drilled into the terrace." Caitlin knew what the terrace was. She'd been 12 years old when she handed us tools on those October weekends. She'd been at the memorial we'd held on the terrace in the spring after Margaret died. 40 people standing on Margaret's flagstone in the April afternoon. The silence on the phone lasted several seconds. "Are you okay, Dad?" "I'm fine." I was. I was not distressed in the way that invites comfort. I was the way I get when a structural problem has been clearly identified and the correct response is obvious. "Marcus Webb is coming tomorrow at 7. The stage will be gone by noon." Another silence. "Good," Caitlin said. Marcus arrived at 7:02 a.m. I was at the rear gate with 2 cups of coffee and a 4-page document I'd compiled the previous evening, printed on my home printer, clipped together, with a cover sheet that read, "Site Assessment, Unauthorized Construction, 14 Ridgecrest Court, April 16, 2024. 30 years of structural engineering practice produces certain habits: documentation before action, photographic record before any element of the site is disturbed, systematic sequencing from general to specific, wide shots establishing the overall condition, medium shots identifying each component, close shots capturing every anchor point, fastener, and area of damage with a measuring tape and frame for scale." I had started photographing at 3:30 p.m. on Tuesday, within 2 hours of arriving home. I had finished at 7:45 p.m. I had downloaded every image to my laptop, organized them into labeled folders, printed contact sheets, and compiled the 4-page summary document before I went to bed. The document covered: Page 1, overall stage dimensions and configuration. The platform was 40 feet by 24 feet, constructed from 2 by 10 pressure-treated lumber on a standard joist and beam frame, elevated 6 inches off the lawn surface on 4 concrete footings. 3 sides had decorative white painted railings. The 4th side, the rear, was open, facing the back fence. Page 2, the oak tree hardware. String lights had been attached to all 4 trees using 3-inch wood screws, 12 screws total, 3 per tree, driven into the bark at heights between 8 and 14 feet. The screws were not anchor hooks. They were standard wood screws, driven directly into living tree tissue, without any protective barrier. A structural engineer who has reviewed tree damage assessments knows what direct metal penetration does to cambium tissue over time. I'd photographed every screw from 2 angles. Page 3, the concrete footings. 4 footings, 1 at each stage corner. 4-inch diameter, approximately 18 inches deep based on the pour collar visible at grade. New pour. I estimated 72 to 96 hours old, based on the color and surface texture. Each footing photographed with a ruler showing the diameter and a probe measuring the grade elevation. Page 4, the stone terrace. 6 anchor bolt holes, drilled with what appeared to be a 3/8 inch masonry bit, based on the hole diameter. The staging cables, tension bracing for the stage frame, had been anchored to the terrace using drop-in concrete anchors, the kind you drill for, set, and then cannot remove without enlarging the hole. 3 of the holes were in the large flagstone with the diagonal red vein at the terrace's north edge. The drilling had fractured the stone along a natural fault line that ran parallel to the vein. The crack was full width. The stone was structurally compromised. It would not survive being walked on. I handed Marcus the document with his coffee. He read it standing at the rear gate, scanning each page with the efficient attention of a contractor who reads site assessments for a living. "The footings are the issue," he said. 18 inches. I'll need the bucket on those. That's what I figured. Break them at grade and extract. I want the lawn damage photographed after each one comes out. What about the platform material? Disassemble and load. I don't want it cut. I want it intact so the HOA can identify it as their equipment. I paused. This is going on a flatbed. I want it available for the legal proceeding. Marcus nodded. He'd been in this business long enough to recognize when a job was being documented for purposes beyond the removal itself. 7 to 10, he said. We'll be done by 10. He was right at 3 hours. The skid steer was a Bobcat T595, compact track loader, the right machine for a residential lawn, where you want maneuverability without tearing up ground you're not targeting. Marcus's operator, a young man named Derek who worked with the precision of someone who'd been running equipment since before he could legally drive, positioned the machine at the first footing at 7:20 a.m. I stood at the terrace and documented. The skid steer bucket broke the first footing at grade with a single firm downward strike. The crack was audible from where I stood, 20 feet away. Derek worked the bucket under the broken footing, extracted it, and set it on the tarp Marcus had laid on the driveway. I photographed the hole left in the lawn, approximately 9 inches across at the surface, tapering to the footing diameter, with the characteristic ragged edge of concrete extraction from clay soil. The second footing took 2 strikes. The third and fourth came out cleanly. By 8:15 a.m., all 4 footings were on the tarp, and the footing holes had been photographed. The stage disassembly was methodical. Marcus and Derek worked the platform from the open rear side forward, disconnecting the railing sections first, then pulling the decking boards, then the joists, then the beam frame. Everything was labeled with blue painter's tape as it came apart. Marcus's standard practice on removal jobs, where the material was being preserved rather than demolished. Each piece was loaded onto the flatbed in sequence. While they worked the platform, I removed the hardware from the oak trees. I used a standard screw extractor, the kind you use to remove a fastener that's been driven flush or slightly below the surface. 12 screws, 3 per tree, each one extracted cleanly and placed in a labeled plastic bag. I photographed each screw hole after extraction, the wood tissue around each entry point, the sap response that had begun around 2 of the screws on the westernmost tree, the depth of penetration visible when I angled a flashlight into the holes. A licensed arborist would later assess the tree damage at $2,200 total, minor compared to the terrace, but documented. The staging cables came off the terrace last. I photographed the anchor bolt holes before removal and after. Before, the bolts in place, the cables attached, the load angle visible. After, the holes bare, the crack in the large flagstone fully visible without the cable hardware obscuring it, the fracture line running clean and complete from one edge of the stone to the other. I stood at that stone for a moment after the last bolt came out. The crack had not worsened during the removal process. It was what it had been when I first saw it Tuesday afternoon. A single fracture, full width, along the natural fault line. Not repairable. The stone would have to be replaced. It could be replaced with flagstone. It could not be replaced with that flagstone. The Tennessee quarry Margaret had sourced it from had closed in 2016. Somewhere in the world there might be stone with a similar red vein pattern. It would not be the same stone. It would not be the stone she had selected, handled, positioned, and set on an October Saturday in 2009. I photographed it from 4 angles and went inside to call Claire Sung. By 10 a.m., the flatbed was loaded and covered with a cargo net. The rear lawn showed the 4 footing extraction holes, the slight compression marks from the skid steer tracks, and the area of disturbed soil where the stage frame had rested. Marcus had done what good contractors do. The extraction damage was limited to what the removal structurally required. I walked the lawn and photographed the full extent of the ground disturbance. Then, I photographed the oak trees one final time, each hardware hole visible, each tree in its full context. Marcus handed me the job documentation. His own site record, equipment hours, material inventory of everything loaded on the flatbed. "Where do you want this delivered?" He meant the flatbed. "Your yard. Hold it pending legal instruction." "Understood." He paused. "Thomas, everything okay?" I looked at the rear lawn, the oak trees, the terrace with its cracked stone. "It will be," I said. He pulled out of the driveway at 10:07 a.m. I called Claire Sung at 10:31 a.m. At 11:15 a.m., a car pulled into the cul-de-sac and stopped behind my vehicle. I was in the kitchen when I heard the car door. I went to the front window. She was walking toward my front door with the specific energy of someone who has received alarming information and has decided that physical presence is the appropriate response. I opened the door before she knocked. She stopped on my front steps and looked past me, or tried to, angling her sightline toward the rear of the house, toward the lawn where the stage had been. "What have you done?" Her voice had the quality of controlled fury, the version that presents as indignation rather than anger. "That equipment belongs to the HOA. The committee contracted for that installation. You had absolutely no right." "You had no right to build it," I said. "I had every right to remove it. The events committee authorized. The events committee has no authority over my private property." I kept my voice level, the same tone I used for 30 years when a contractor had deviated from specifications and needed to be corrected without the conversation becoming something other than professional. "You were told no in April 2023. You were told no in writing in September 2023. You accessed this property with a key that exists for emergencies while I was away, and you poured concrete footings into my lawn and drilled anchor bolts into my wife's stonework." Something shifted in her expression when I said that. Not remorse, not yet, and in Brenda's case, possibly never, but a recalibration. The indignation had been calibrated for a different response than the one she was receiving. She had expected upset, she had expected negotiation or confrontation, or the kind of agitated homeowner who can be managed by a confident committee chair who controls the social dynamics of the community. She had not expected a man who had spent the previous evening documenting every square inch of the construction and the morning removing it with professional equipment, and who was now standing in his doorway with the specific calmness of someone who has already moved to the next step. "You're going to pay for that equipment," she said. The indignation was receding. What was underneath it was less certain. "I look forward to seeing that argument in court," I said. I closed the door. I stood in the entry hall for a moment. Through the rear windows, the oak trees were visible, the empty lawn, the terrace with its cracked stone. I went back to the kitchen table, opened the site assessment document, added a time-stamped note. Brenda Colton arrived at property, 11:15 a.m. Verbal confrontation at front door. Duration, approximately 4 minutes. Statements recorded above. Then I called Claire back with the update. "She came to the house," I said. "What did she say?" "That the equipment belonged to the HOA and I had no right to remove it, that I was going to pay for it." Claire was quiet for a moment. "What did you say?" "That I looked forward to seeing that argument in court." A pause. "Good," Claire said. "That's exactly right. Don't say anything else to her directly from this point forward." "I know." "Thomas, you have the full documentation from last night and this morning?" 4-page assessment. 247 photographs, time-stamped. Marcus Webb's job record, his equipment logs. I have the anchor bolts themselves, the hardware from the trees in labeled bags, and the staging cable sections. A longer pause. "You're going to be a very good client," Claire said. Claire Sung had been practicing HOA and property litigation in Atlanta for 16 years. She had the particular quality of a specialist who has seen every variation of a category of dispute. The overreaching HOA board, the self-appointed authority, the governing document that says one thing while the board member insists it says another, and has developed the efficient precision that comes from knowing exactly where to look and what to look for. She asked me to send the full documentation package on the evening of April 16th. I sent 247 photographs, the 4-page site assessment, Marcus Webb's job record, and my 2 written refusals to Brenda's use requests. The September 2023 letter, and my notes from the April 2023 verbal refusal at the HOA meeting, which I'd made contemporaneously in my property notebook. She called me the following morning. Before we discuss the damage assessment, I want to walk through the authorization question, because that's where this case begins. Go ahead. I've reviewed the Magnolia Ridge Community Association CC and RS and bylaws. I pulled them from the Cherokee County Public Records last night. The Events Committee's authority is defined in Article 7, Section 3 of the bylaws. She paused. The relevant language. The Events Committee is authorized to plan, organize, and execute community social events and activities on association common property and facilities. That's the full scope. Common property only. Common property only. There is no provision in the CC and RS, the bylaws, or the Events Committee Charter that authorizes the committee to use, access, or contract for construction on private residential lots. Not with owner consent, not without it. The provision simply doesn't exist because no one drafting an HOA governing document contemplates writing an authorization for a committee to conduct operations on land the association doesn't own. I'd expected this. The governing document limitation was the foundational issue. Everything else built on it. The authorization memo, I said. That's the part I want you to hear carefully. Another pause. When the events committee contracted with Premier Stage Solutions for the installation, Brenda signed the contract as Magnolia Ridge Community Association Events Committee Chair. The contract referenced a 1-page authorization memo attached to the contract as an exhibit that stated the following. I heard paper. This memo confirms that the Magnolia Ridge Community Association Board of Directors has approved the use of the residential property located at 14 Ridgecrest Court for the 2024 Community Gala event installation, subject to standard community guidelines. The kitchen was quiet. The board approved no such thing, I said. I contacted all 5 board members independently, separate calls, yesterday afternoon and this morning. All 5 confirmed the same thing. There was no board meeting, no vote, no discussion, and no approval of any use of your property. 3 of them said they had no knowledge of the installation until they saw it. She paused. The other 2, including the board president, a man named Gary Holt, said Brenda had mentioned at an informal board social gathering in February that she was working on securing the Aldrich property for the gala. Neither of them responded to that statement. Neither of them gave any approval. She wrote a memo claiming board approval that didn't exist. She wrote a memo claiming board approval, attached it to a $34,000 construction contract, used it to authorize entry to your property, and proceeded with a full installation. Claire's voice was the flat precision of an attorney who has assembled a fact pattern and is delivering it without editorial comment, because it doesn't need any. Thomas, that memo is the center of this case. It's the document that converts an unauthorized committee action into something considerably more serious. Claire retained a licensed contractor for the formal damage assessment on April 19th. His name was Robert Faraday, 28 years in residential construction, a specific background in masonry and hardscape restoration. Claire had used him before in HOA property damage cases. He arrived at 14 Ridgecrest Court on a Thursday morning with his own camera, a measuring tape, a masonry probe, and the systematic approach of someone who understood that his assessment would be entered into a legal proceeding and needed to be defensible under cross-examination. I walked him through the property in the same sequence as my own documentation: oak trees, lawn, terrace. He spent 40 minutes on the terrace. He examined each anchor bolt hole individually, probing the depth, measuring the diameter, assessing the condition of the stone surrounding each hole. He photographed the cracked flagstone from every angle, placed a measuring tape along the fracture line to document its full length, and used a straight edge to demonstrate the vertical displacement at the crack. The 2 halves of the stone had shifted slightly relative to each other, a consequence of the drilling vibration that had initiated the fracture. He knelt at the cracked stone for a long time without speaking. Then he stood and looked at the terrace as a whole. "This is hand-set work," he said. It wasn't a question. "My wife said it in 2009. We did it together." He nodded slowly, the nod of a craftsman who has encountered work he respects and is now being asked to assess damage to it. "The stone selection is careful. Whoever laid this took time with the joints, The spacing is consistent within 2 millimeters across the whole surface. That's not typical residential hardscape. That's someone who was paying attention. She was. He finished the assessment in 3 hours. His written report came back to Claire on April 22nd. Stone terrace, 6 anchor bolt holes and hand-set Tennessee flagstone. The drilling had been performed without any attempt to avoid natural fault lines in the stone. A basic masonry practice when drilling into natural stone is that you examine the stone for existing fractures and position anchors to avoid accelerating them. Whoever had installed the staging anchors had drilled without that assessment. 3 flagstones showed fractures radiating from or along the anchor holes. Replacement of the 3 damaged flagstones, $18,400. The figure reflected the cost of sourcing comparable Tennessee flagstone, professional removal of the damaged pieces without disturbing adjacent work, and hand-setting of replacements by a skilled mason. Faraday had noted in his report that exact matching was unlikely. The Tennessee quarry that had supplied the original stone had closed in 2016, and that the replacement stones would be visually distinguishable from the originals. Full terrace restoration to original condition, $31,200. This figure represented complete removal and replacement of the entire terrace surface using the best currently available comparable stone, restoring the overall visual unity that partial replacement could not achieve. Lawn damage from the 4 concrete footing extractions, $4,800. Resodding, soil amendment, and grade restoration for the 4 extraction zones. Oak tree hardware damage, $2,200. Arborist assessment and treatment for the 12 screw penetrations, including wound sealant application and a 2-year monitoring protocol for cambium damage. Total documented property damage, $38,200. Claire called me when the report came in. Faraday's numbers are solid. He's testified in Cherokee County Superior Court 4 times, and his assessments have held up under cross-examination each time. The $38,200 is the documented baseline. She paused. I want to talk to you about the master key, the rear gate access. The HOA Management Company, Magnolia Ridge is managed by Summit Property Management, holds a master key for emergency access to residential rear gates. It's standard practice in HOA communities with management contracts. The key is held for situations like a resident is incapacitated and can't open their gate for emergency services. A water main break requires access to a rear yard utility, that kind of thing. The key is not authorized for general access. The management contract specifies emergency use only, and Brenda used it. Brenda called the Summit Property Management Office in late March. I've obtained the call log through a records request, and requested the master key for your gate, citing HOA event preparation. The Summit employee who released the key did not verify the authorization, did not contact the board to confirm the event preparation was legitimate, and did not require Brenda to document the purpose in writing. I thought about that for a moment. So Summit released an emergency master key to a committee chair for non-emergency use without verification. Yes, Summit has exposure here. Negligent release of access credentials. We'll be naming them as a secondary party in the civil action. She paused. But the primary authorization problem is Brenda's. She requested the key using a false purpose. She used it to access your property. She authorized a construction contract using a fabricated board approval memo. The sequence is documented. What are we filing with the Sheriff's Department? Criminal trespass under Georgia Code Section 16-7-21. Intentional entry onto private property without authority and remaining after it's known that permission has been denied. She paused. Thomas, you had said no, twice. Once verbally, once in writing. That written refusal is the critical document. It establishes beyond any ambiguity that Brenda knew permission had been denied before she entered. What about the construction, the concrete footings? Georgia also has a criminal mischief statute, Section 16-722, that covers intentional damage to private property. The anchor bolt damage to the terrace, combined with the documented prior refusals, gives us a strong argument for that count as well. She paused. I'm filing both with the Cherokee County Sheriff's Department tomorrow morning, along with the full documentation package. The memo, I said, the fabricated board approval memo, is that a separate criminal matter? Potentially. It's fraud. using a false document to obtain services and property access. The Cherokee County DA's office will make that determination once the Sheriff's Department has the file. I'll flag it explicitly in the referral. The Sheriff's Department acknowledged receipt on April 24th. An investigator, Detective Renee Cartwright, Cherokee County Sheriff's Criminal Investigations, called Claire on April 26th to confirm she'd received the file and was reviewing it. She called back on April 30th. Ms. Sung, I've reviewed your client's documentation. The photographic record is thorough. A pause. I've also reviewed the authorization memo your client provided. I'm going to need to speak with the 5 board members your letter references. All 5 have been cooperative with my office. I'll provide their contact information. One more thing. Another pause. The memo is dated February 12th, 2024. Your client's written refusal is dated September 14th, 2023. Whoever wrote the memo was aware of the prior refusal, or should have been, given that it was addressed to the events committee. Yes, Claire said. So the memo was written to authorize access to a property that had already formally declined the access request. Correct. Detective Cartwright was quiet for a moment. We'll be in touch. I learned about the memo's full implications on a Thursday evening, when Claire called with an update from her board member interviews. Gary Holt, the board president, had provided a specific detail that hadn't emerged in the initial contact. At the February social gathering where Brenda had mentioned working on securing the Aldridge property, she had also mentioned my September 2023 written refusal. She had described it as not a final answer. She had told the board, casually, at a social event, without a vote or a formal discussion, that she intended to approach the situation differently for the 2024 gala. Gary Holt had said nothing in response. He had not told her to stop. He had not reminded her that the property owner had declined in writing. He had accepted another drink and let the conversation move on. He's not criminally liable, Claire said, but he's going to have a very uncomfortable deposition. Brenda told board members about my refusal, I said. Yes. And then wrote a memo claiming the board had approved access to the property she'd been refused. Yes. The kitchen was quiet. Claire, how does a person write that memo? She was quiet for a moment. In my experience, the same way people do most things like this. She wanted it to be true. She convinced herself that her wanting it was close enough to authorization, that the board's silence was consent, that the community benefit justified the method. A pause. People who organize things for a long time sometimes stop distinguishing between their authority to want something and their authority to do it. I looked out the rear window at the terrace, the cracked stone, the anchor bolt holes. She drilled into Margaret's stonework, I said, because she wanted a nice backdrop for a party. Claire didn't answer that. There wasn't an answer that improved on the statement. I'll file the criminal referral tomorrow, she said. The civil action follows next week. The HOA board emergency meeting on April 29th had one item on the agenda. Susan Park, the insurance carrier's attorney, driven up from Atlanta after Claire's civil complaint landed on the carrier's desk, had reviewed the full file before she walked in the room. Governing documents, events committee charter, the authorization memo, the Premier Stage Solutions contract, the damage assessment. She delivered her position in the first 20 minutes. The events committee's authority was explicit and limited, common property only. There was no arguable interpretation of plan and execute community events on association common property that extended to constructing a permanent installation on a private residential lot. The attempted extension was not a gray area. It was a committee chair operating entirely outside her defined authority on a matter where the property owner had twice said no. The HOA had exposure on 2 bases. First, Summit Property Management had released the emergency master key without verification. Summit was the HOA's agent. Their negligent release was attributable to the association. Second, the HOA had paid the $34,000 Premier Stage Solutions invoice, processed through the operating account on the basis of Brenda's contract submission, which included the fabricated board approval memo, without independent verification. The HOA had funded an unauthorized trespass. Gary Holt. Can we argue Brenda acted outside her authority and the association isn't responsible? Susan Park. She signed the contract as events committee chair. She used the key held by our management agent. The association paid the invoice. At every step, she was acting in her stated committee capacity. A pause. Gary, she forged a memo. Brenda's defense, submitted through her personal attorney in early May, made two arguments. The first, that plan and execute community events implicitly included venue preparation. That staging infrastructure was a natural component of event execution. Claire's response, filed May 12th, was two sentences. Mr. Aldridge said no twice, verbally in April 2023, in writing in September 2023. Planned community events does not mean pour concrete footings on private residential property after the owner has said no in writing. The second argument, implied consent. Thomas's failure to install a lock on his rear gate constituted implied consent to HOA access for community purposes. Claire's response was a single paragraph. Mr. Aldridge's gate was unlocked because he lived in a residential neighborhood where he had no reason to expect that a committee chair would conduct construction operations during his 12-day absence. An unlocked gate is not implied consent. It is an unlocked gate. If Ms. Colton's position is that any accessible property is available for HOA events, the court is invited to apply that standard to her own rear yard. The financial picture had a specific absurdity worth stating plainly. Premier Stage Solutions had been contracted for $34,000. The contract used the events committee's delegated spending authority for common area improvements, a reasonable provision for tent rentals, catering, audio equipment. Brenda had used it to pay for construction on private property. The HOA had spent $34,000 in community funds on an installation that produced zero community benefit, had existed on Thomas's property for 9 days without his knowledge, and had generated $38,200 in documented property damage. The stage was on a flatbed in Canton, Georgia. The board voted on removal on May 3rd. Gary Holt, against. Carol Sims, against. Rita Moss, David Chandra, Paul Everett, in favor, 3-2. Brenda was removed from the events committee, effective immediately. She called Gary Holt from her driveway and threatened to sue the board for wrongful removal, defamation, and intentional infliction of emotional distress. Her attorney, when consulted, suggested she reconsider. The threatened suit was not filed. What was filed was a cross-claim in the civil proceeding, attempting to redirect HOA liability onto Brenda individually, while simultaneously arguing that her removal was retaliatory and had caused professional and reputational harm. She was asking for $85,000 from the HOA. Susan Park's assessment to the board. She is suing you for firing her after she spent your money to trespass on a resident's property and drill holes in his wife's memorial stonework. I've handled a lot of HOA litigation. This is in the top 5. The 3 cooperating board members, Rita Moss, David Chandra, Paul Everett, had each provided sworn statements confirming they had not authorized the installation, had not been consulted about the memo, and had received no advance notice of the construction. Claire noted in her case summary, the board's fracture establishes that the authorization failure was Brenda's individual action, not an institutional decision. That distinction is essential for the punitive damages argument, which is against Brenda personally. Claire filed on May 15th, 43 pages, named defendants, Brenda Colton, individually, and the Magnolia Ridge Community Association. The complaint opened with a 4-paragraph factual summary that required no legal argument to be damaging. The 2 written refusals, the fabricated authorization memo, the emergency key misuse, the concrete footings, the anchor bolts, the cracked flagstone, and then moved into the counts. Count 1. Criminal trespass and unauthorized construction. Georgia law is direct on intentional entry onto private property after permission has been explicitly denied. The written refusal of September 14, 2023, established denial of permission with no ambiguity. Brenda had entered the property 8 months later, using a key obtained under false pretenses. The construction she had authorized, concrete footings, anchor bolts, hardware screwed into living trees, constituted unauthorized construction on private property. Damages, $75,000. Count 2. Destruction of personal property. The anchor bolt damage to the stone terrace, 6 holes, 3 cracked flagstones, 1 fractured beyond repair, met the legal standard for willful destruction of personal property. Robert Faraday's assessment was attached in full. Full terrace restoration cost, $31,200. Damages, $31,200. Count 3, intentional infliction of emotional distress. This was the count that changed the tone of the case. Claire had asked me to write a statement for the court, personal, factual, in my own words. She told me not to write for sympathy. Write what is true, she said. Let the facts carry it. I wrote it at the kitchen table on a Sunday evening in early May. 3 paragraphs. I revised it once. My wife Margaret set every flagstone in that terrace by hand. She designed it, she sourced the stone, and she spent 3 weekends in the fall of 2009 building it with me. She died in January 2022. That terrace is not landscaping. It is the last significant physical thing she made. Brenda Colton drilled 6 anchor bolts into it while I was away visiting my daughter. 3 of the flagstones are cracked. They cannot be repaired. They can only be replaced. And replacement is not restoration. Claire read it and was quiet for a moment. This goes in verbatim, she said. I'm not editing a word. It was attached to the complaint as Exhibit J. Damages on the emotional distress count, $120,000. Count 4, punitive damages. Georgia law authorizes punitive damages when the defendant's conduct shows willful misconduct, malice, or that entire want of care which raises the presumption of conscious indifference to consequences. The conduct here was not inadvertent. Brenda had been told no in April 2023. She had been told no in writing in September 2023. She had written a memo falsely claiming board approval. She had obtained a key under false pretenses. She had proceeded with a construction installation on a property where the owner's refusal was documented, known, and deliberately circumvented. 2 written refusals, a fabricated authorization document, an 8-month plan to proceed regardless. Punitive damages, $240,000. Total demand, $466,200, plus attorney fees and costs. The first hearing was June 3rd. Cherokee County Superior Court, Judge Harold Benning presiding. A motions hearing. Brenda's attorney had filed 2 motions to dismiss, both of which Claire had anticipated and prepared responses to. But the procedural calendar was briefly interrupted. Brenda had filed a counterclaim against Thomas. The counterclaim alleged that Thomas had willfully destroyed $34,000 in event staging equipment belonging to the Magnolia Ridge Community Association by having it removed from his property without authorization. Judge Benning reviewed the counterclaim for approximately 90 seconds. Ms. Colton, he looked at Brenda's attorney. Your client's counterclaim alleges that Mr. Aldridge destroyed $34,000 in equipment by removing it from his property. That's correct, Your Honor. The equipment was... Where is the equipment now? Brenda's attorney paused. It was taken by a demolition contractor. Is it intact? Another pause. I believe so, Your Honor. It's being stored. So it wasn't destroyed. It was removed. Judge Benning set the counterclaim down. Mr. Aldridge removed unauthorized construction from his own property. A property owner has an unambiguous right under Georgia law to remove trespassing structures. He did not damage the equipment. He removed it. The equipment is on a flatbed somewhere. He looked at Brenda's table. What is your actual claim? Brenda's attorney had no answer that improved the situation. Counterclaim dismissed. He moved to the motions. Mr. Sung, let's proceed. Both of Brenda's motions to dismiss were denied. The first had argued that the Events Committee's general authority implicitly covered venue preparation, and that the complaint failed to state a claim on the trespass count. Judge Benning's ruling was brief. The governing documents limited committee authority to common property. The property at 14 Ridgecrest Court was not common property. The motion failed on its face. The second had argued that Thomas's emotional distress claim was insufficient because the damage to the terrace was property damage, not personal harm, and that the emotional distress count improperly attempted to convert property damage into a personal injury claim. Judge Benning had Thomas's statement in the file. He read it into the record. The courtroom was quiet while he read. The full 3 paragraphs. Every flagstone. 3 weekends in fall 2009. January 2022. The last significant physical thing she made. He set it down. Counsel, the intentional infliction of emotional distress claim in Georgia requires that the defendant's conduct was extreme and outrageous, that the conduct was intentional or reckless, and that the plaintiff suffered severe emotional distress as a result. He looked at Brenda's attorney. The plaintiff's statement describes a deliberate act, drilling anchor bolts into a hand-built stone structure that the plaintiff has identified as the primary physical memorial to his deceased wife, conducted after 2 written refusals and using a key obtained under false pretenses while the plaintiff was away visiting his daughter. He paused. I'm not prepared to rule at this stage that this conduct cannot constitute extreme and outrageous behavior. The motion to dismiss on count 3 is denied. Both motions denied. The case would proceed to trial. The HOA's insurance carrier had been in settlement discussions with Claire since mid-May. Susan Park and Claire had a productive working relationship. 2 attorneys who understood the legal position on both sides and were working toward a number that reflected the association's actual exposure without requiring a trial that would be damaging to the community's reputation, regardless of outcome. The association's exposure was real, and Susan Park had been clear about it with the board. The management company's key release, the invoice payment, the operating account mechanism Brenda had exploited, these were institutional failures that the carrier would defend but could not make disappear. The 3 cooperating board members had voted in favor of settlement in principle in late May. Gary Holt and Carol Sims had abstained. They were not willing to vote against settlement, but they were not willing to vote for it either. The 3-vote majority was sufficient. The settlement was reached on June 19th, $180,000, funded through the HOA's liability policy. The settlement covered the association's share of the trespass damages, the property damage, and a portion of the emotional distress claim. It specifically carved out any coverage for Brenda Colton's personal liability. The carrier's position was that Brenda had acted outside the scope of her committee authority, and her personal exposure was not the association's insurance obligation. The settlement document included a clear statement. The Magnolia Ridge Community Association acknowledged that the events committee had no authority to access or construct on private residential property, and committed to a governing document amendment explicitly prohibiting committee use of private lots without written owner consent and formal board approval. The governing document amendment was drafted by Claire and adopted by the board in July. It was, in the end, the one useful thing the entire episode produced for the community. Brenda Colton's personal liability, $286,200, the balance of the total demand after the HOA settlement, remained active and unresolved. Her trial date was set for October. I was at the kitchen table when Claire called with the HOA settlement confirmation. $180,000, signed and funded. The association is out. And Brenda goes to trial in October unless she settles before then. Her personal exposure is $286,200, plus whatever the judge awards in attorney fees. A pause. Thomas, her attorney has been making quiet overtures about settlement for 3 weeks. She knows what the trial looks like. What does it look like? It looks like a judge who has already read your statement into the record in open court, a 3-count complaint with strong documentation on every count, 2 board members who have provided cooperative sworn statements about the fabricated memo, and a countersue that was dismissed in the first hearing for being legally incoherent. She paused. It looks like a case she doesn't win. I looked out the rear window. The terrace, the cracked flagstone catching the afternoon light, the way it always caught the afternoon light. The red vein still visible despite the fracture, still doing what Margaret had wanted it to do when she positioned it on that October morning in 2009. Tell her attorney I'm not settling, I said. Brenda made a decision to proceed after 2 written refusals. She can explain that decision to a jury. The trial lasted 4 days, October 14th through October 17th, Cherokee County Superior Court. Judge Benning presiding. The same judge who had read Thomas's statement into the record in June, dismissed Brenda's counterclaim in the same breath, and denied both motions to dismiss without significant deliberation. Brenda's attorney had made 3 more settlement overtures between June and October. The final one, delivered 2 weeks before trial, had offered $140,000, a number that reflected Brenda's assessment of her liquid assets, more than her assessment of her legal position. Claire had conveyed each offer. I had declined each one. The trial record was the documentation I'd compiled on the evening of April 16th and the morning of April 17th. 247 photographs, the site assessment, Marcus Webb's job record, the 2 written refusals, the fabricated authorization memo, with the board members' sworn statements confirming it had no basis in any actual vote or approval. Detective Cartwright's investigation file, Robert Faraday's damage assessment. Brenda's attorney made the same arguments he'd made in June: implied consent, committee authority, good faith community purpose. Judge Benning had already ruled those arguments insufficient at the motion stage. Presenting them again to a jury did not improve them. The jury deliberated for 6 hours. Verdict: for the plaintiff on all 3 counts. Criminal trespass and unauthorized construction, $75,000. Destruction of personal property, $31,200. Intentional infliction of emotional distress, $120,000. Punitive damages, $240,000. Attorney fees, $28,400. Total civil judgment against Brenda Colton personally, $494,600. Less the HOA's prior settlement of $180,000, allocated against the trespass and property damage counts. Net personal judgment against Brenda, $314,600. The criminal proceeding had concluded separately in September, a guilty plea to criminal trespass, negotiated by Brenda's criminal defense attorney in exchange for the prosecutor dropping the fraudulent document count. Misdemeanor conviction, $4,000 fine, 18 months probation. The board's final vote on committee removal, conducted after the criminal conviction, was 5-0. Gary Holt and Carol Sims, who had abstained on the earlier vote, voted in favor this time. The criminal conviction had resolved whatever ambiguity they'd been maintaining. I called the stonemason in November. His name was Arthur Gaines. He'd been recommended by Robert Faraday, who'd encountered his work on a period restoration project in Buckhead. He specialized in natural flagstone work, with particular experience in matching and integrating replacement stone into existing installations. He was 64, had been working stone since his 20s, and had the particular patience of a craftsman who understands that his job is not to impose his vision on a material, but to listen to what the material requires. He came to the property on a Tuesday morning and spent an hour on the terrace before he said anything substantive. He examined the cracked stones individually, the large piece with the red vein, the 2 smaller damaged pieces on the terrace's east edge. He looked at the joint spacing, the coursing pattern, the way the stones had been laid in relation to each other. He asked me who had set the work. I told him. He was quiet for a moment, looking at the terrace. She had good instincts, he said. The way she varied the joint width in the corners. That's not in any manual. That's someone who understood what she was looking at. I didn't say anything. He sourced the replacement stone over 3 weeks, calling quarry contacts across Tennessee and North Carolina, looking for material with the warm gray base and red veining that matched the original as closely as possible. He told me from the beginning that an exact match was not achievable. The quarry Margaret had sourced from had closed in 2016. The specific geological formation that produced that coloration and vein pattern was not being actively quarried anywhere, he could confirm. The closest match he found came from a small quarry in eastern Tennessee, a warm gray stone with faint reddish veining, not identical to the original, but in the same family. He brought samples to the property and laid them on the terrace beside the intact original stones. "It's not the same," he said. "I know. It will be visible. Anyone who looks carefully will see where the new stones are. I know that too." He set the 3 replacement stones over 2 days in December. He worked the way Margaret had worked, on his knees, rubber mallet, checking level with a patience that I recognized from the October weekends in 2009. He matched the joint spacing to within the tolerances of the original work. He fit the new stones to the existing courses with the care of someone who understood that the goal was continuity, not perfection. That a terrace tended through change is different from a terrace replaced, and the difference matters. When he finished, he stood back and looked at it. The new stones were slightly lighter in color than the surrounding originals. The eastern Tennessee stone had less of the deep, warm gray that the original quarry had produced. At 3 points in the terrace, the replacements were visible to anyone looking for them. It was not the same terrace, but it was tended. Caitlin visited in January. She came for 2 weeks, the same span as the Portland trip that had been interrupted by what she still called, in the family shorthand we'd developed, the stage situation. She brought both children, and the house had the specific quality it only gets when there are children in it: noise and motion, and the particular mess of people who are not worried about the furniture. On the second Saturday of her visit, we were on the terrace with coffee. The January morning, cold and clear, the oak trees bare against a pale sky, the replacement stones visible at their 3 points in the surface. She looked at the terrace for a while without speaking. Dad. She held her coffee with both hands, the way she'd held things since she was small, the habit of someone who needs the warmth. Why didn't you just call the HOA first? Before the bulldozer? Before all of it? I looked at the terrace. The new stones, slightly different in color, visible at 3 points. The large piece at the north edge, the one with the diagonal red vein, replaced now with Tennessee stone that was close but not identical, that caught the light differently than the original had caught it on the Saturday morning in October 2009, when Margaret had said it and stepped back and looked at it with the expression she had when something was right. Because they drilled into her stonework, Caitlin. I paused. She built this with her hands. I watched her set every stone. I mixed the compound and she positioned every piece, and she knew exactly where each one belonged. I looked at the replacement stones. Some things you don't negotiate, you just remove. Caitlin looked at the terrace for a long moment. She would have done the same thing, she said. She would have done it faster. Caitlin smiled, the specific smile of a daughter who has heard something true about her mother. We sat on the terrace until the morning warmed enough to be comfortable without jackets. The oak trees above us, the rear lawn, open and empty and properly kept. The terrace underneath us, tended, imperfect, continuous. Brenda Colton had been told no twice, in writing. She had accessed Thomas Aldridge's property with an emergency master key while he was away visiting his daughter. She had poured concrete footings into his lawn. She had drilled anchor bolts into the stone terrace his late wife had built by hand on 3 October weekends in 2009. Thomas had come home on a Tuesday. He'd called a demolition contractor. The stage was gone by 10 a.m. the following morning. 18 months later, Brenda had a criminal trespass conviction, a $314,600 personal civil judgment, a $4,000 fine, 18 months of probation, and no events committee to chair. The stone terrace is still there. It will be there when Brenda's probation ends. It will be there after that.